When people consider Australian colonisation, one term often forms the centrepiece of the discussion: terra nullius. Now, the general person's understanding of the term is relatively straightforward. It refers to land that belongs to no one and was used to justify the United Kingdom's colonisation of Australia in 1788. Everyone, of course, understands that the declaration of terra nullius over Australia was incorrect, as there were in fact Indigenous peoples living on the lands prior to colonisation. Australia's First Nation peoples were deprived of their native lands, and this set the course for centuries of oppression. That is typically where people's general knowledge of the legal aspects of Australia's colonisation starts and ends. But it is important to realise that there are many interesting complexities to Australia's legal foundations, and that these provide an excellent insight into how the native title rights, laws, and customs of Indigenous people were completely disregarded. And that's exactly what we're looking at today. How was English law received into Australia, and how did it interact with and affect the native title, customs, and laws of Indigenous Australians? So the starting point for looking at the legal complexities of Australia's settlement is to consider colonisation at international law and the attitudes of countries, particularly those in Europe, towards it. You see, terra nullius as a concept was a critical component of how colonising countries could justify their occupation of new territory. The Law of Nations, written by international lawyer Emer de Vertel, is arguably the primary treatise on international law throughout the 18th and 19th centuries. According to this treaty, if a colonising nation such as Great Britain found new territory that they believed to be uninhabited or terra nullius, then it was possible for the laws of the colonising nation to apply there. Let's take a look at this extract from Book 1 of de Vertel's The Law of Nations. Section 205, Acquisition of Sovereignty over Unoccupied Territory. It says when a nation takes possession of a country to which no prior owner can claim, it is considered as acquiring empire or sovereignty of it at the same time with the domain. So we can see de Vertel is making clear that the laws of a colonising nation will apply to land that is considered to be terra nullius. Now, this has complexities in itself as to the extent this will occur, but we'll place that to the side for a moment and consider just how Australia, a country that was occupied, nonetheless was declared to be terra nullius. Captain James Cook noted a week after landing at Botany Bay that the natives do not appear to be numerous, and that neither do they seem to live in large bodies, but dispersed in small parties along by the waterside. This of course begs the question, if the newly discovered territories were sparsely occupied, could the British nonetheless claim sovereignty over them? This wasn't a novel issue, as similar questions had been asked about colonies established in North America, but this time it would have a very different outcome. It was generally thought that small groups could not make claims over large expanses of land, as this could lead to ridiculous claims. De Vertel supported this view in his The Law of Nations, arguing that small groups could not claim large areas as they couldn't make effective use of it, and he notes that they would have no reason to complain if other nations, more industrious and too closely confined, come to take possession of a part of those lands. But perhaps the most critical factor in support of the English decision to declare Australia terra nullius is the lack of agriculture. You see, the Indigenous Australians were nomadic peoples and did not rely on establishing settlements with crops and livestock. Instead, Indigenous people were hunter-gatherers, those whose movements were dictated primarily by the availability of resources. To the British colonisers, this indicated a society that was underdeveloped and was unable to claim property rights in the land. Of course, at the time of Australian colonisation, Britain's imperial policies, as they had been for centuries, were dictated by mercantilist ideas about the nature of wealth and international trade. As was argued by Tory economist Joseph Child in a discourse of the nature, use and advantages of trade, there was a necessary link between land ownership and the generation of wealth and prosperity. This was because land ownership permitted agriculture, and this was viewed as the foundation of property, according to the British. The ties between agricultural societies and property rights were also a fundamental component of John Locke's labour theory of property. He argued that nomadic people who are hunter-gatherers have no property rights in the land they travel through, merely in the food they obtain. So the British believed that the nomadic hunter-gatherers that were the Indigenous Australians could claim no property rights over the lands they occupied, and hence it was a straightforward step to declare the country terra nullius. In fact, to clarify any doubt, in the case of Cooper and Stewart, an 1889 decision of the Privy Council, the concept of terra nullius was said to refer not only to land that would belong to no one, but also land that wasn't under the occupation or control of an established government. So we're clear how terra nullius was able to be declared over Australia, allowing Britain to colonise and introduce its system of laws. But exactly how this introduction of English law into Australia took place, and how it affected Indigenous laws, customs and rights, is our next point of focus. So at this point, we need to look at this guy, Sir William Blackstone. He was an English judge, jurist, and professor of law at Oxford in the 18th century, and he wrote a rather famous treaty known as the Commentaries on the Laws of England. Now, why is Blackstone and his treaty so important? Well, in it, he discusses something that would set the groundwork for Australia's inheritance of English law, the colonial birthright theory. The basis for the colonial birthright theory is that upon colonisation, territories are subject to different applications of the law depending on how they are colonised. In the event that lands are taken over by conquest, then the law of the conquered territory will continue to exist until it's changed by the colonisers. In another situation, lands may be taken via cession, which is essentially a treaty, in which case the laws of the colonising nation will apply and existing laws will continue to exist until changed. Finally, as Blackstone put it, if a colony is claimed by right of occupancy only, finding them desert and uncultivated, then all the English laws are immediately there in force. And this, the last option, the settlement rule as it is called, is relevant to Australia due to the declaration of terra nullius. So that's it then. Australia was claimed to be unoccupied, and then according to the colonial birthright theory, all English laws were immediately there in force? Well, not exactly. You see, Blackstone had to go and add a proviso to his theory, that being that new colonies founded on unoccupied territory would carry with them only so much of the English law as is applicable to their own situation. This proviso created much uncertainty as to the content of the English law to be received into the new colony, particularly whether it applied to all of the common law, statute, and equity. It is worth noting what I mean by these things. You see, in the English legal system, there are different sources from which the law will come. Common law refers to the body of law containing all of the decisions of judges in the courts. Statute, rather obviously, refers to legislation that is enacted by parliaments. Finally, there is equity, perhaps the most challenging body of law to explain simply. It originates from the Court of Chancery in the United Kingdom and focuses more upon notions of justice and fairness in its decisions, as opposed to the strict rules that you'll find in common law and statute. So, as we can see, the reference in the colonial birthright theory to all English laws is not straightforward, as there are in fact three separate bodies. As such, there was definitely confusion as to how these different components of the law would be inherited into the new colony, particularly since New South Wales began to move away from its penal roots. So how was the issue of uncertainty for the inheritance of statute, common law and equity to be resolved? Well, there are two acts we need to consider, the New South Wales Act of 1823 and the Australian Courts Act of 1828. Firstly, let's look at the New South Wales Act of 1823. At a base level, this act established Supreme Courts in both New South Wales and Van Diemen's Land, which is now Tasmania. However, a particular section of this act is important to look at, Section 9. This provides the Supreme Courts in both New South Wales and Van Diemen's Land with the power to deal with equitable cases. You see, equity as a body of law was not carried over into Australia with the colonists in 1788, despite Blackstone's reference to all of the laws of England. The granting of equitable jurisdiction can only be done via statute, such as the New South Wales Act. As such, with the enactment of this act, then could it be said that equity as a body of law was received into the colonies. The other act we'll consider, the Australian Courts Act of 1828, looked to consolidate the status of statute and common law in the new colonies. Taking a look at Section 24 of this act, we see that all laws and statutes in force within the realm of England at the time of the passing of this act shall be applied in the administration of justice in the courts of New South Wales and Van Diemen's Land, respectively. Take notice of the phrase all laws in this section. Given that Section 9 of the New South Wales Act had already given equitable jurisdiction to the Supreme Courts, it must be assumed that the reference to all laws in Section 24 actually only means the common law. You'll also notice the words, at the time of the passing of this Act. Does this mean that the common law and statutes of England were not received into the new colonies until the 25th of July 1828, the date of the enactment of the Australian Courts Act? Well, not exactly. Whilst it is accepted that this date could be the point at which statute law was received into the colonies, the stance is different for the common law. The Australian Courts Act could not serve as a source of common law in the Australian colonies, as this was found in the English legal system itself. High Court Justice Sir Victor Windeyer explains it as follows. So that today lawyers look to the statute of 1828 as the root of title of our inheritance of the law of England. But we must not think of it as the source of that inheritance. The source is the common law itself. The law of England had come to Australia with the first fleet 40 years before 1828. So where do we end up in regards to how each of the three main bodies of law were inherited into Australia? Well, Blackstone's colonial birthright theory was correct in that English common law was received with the establishment of the New South Wales colony in 1788. However, equity was received with the enactment of the New South Wales Act in 1823, and statute law received with the enactment of the Australian Courts Act of 1828. As such, now that we understand the nature of the Australian inheritance of English law, it is possible to look at how said law impacted Indigenous rights, laws and customs. Aboriginal people are thought to have occupied Australia for at least 65,000 years prior to colonisation. They were not one homogenous group, but instead there were potentially over 600 different language groups across Australia. Prior to colonisation, Aboriginal communities featured a complex body of rules and traditions which has come to be classified as customary law. Customary law cannot be categorised in the same way as the system Australia inherited from England. It ties in directly with how Indigenous people have interacted with their native lands, flora and fauna for thousands of years. It undoubtedly has various mechanisms that allow Indigenous communities to be regulated, as well as disputes to be resolved. Dr. Diane Bell provides a nice description of customary law that sums up the concept. She describes it as both a body of rules backed by sanctions and a set of dispute resolution mechanisms. At a more informal level, it was also a series of accepted behaviours which allowed daily social life to proceed. Well, as we have established, Australia was declared to be terra nullius and hence was a settled colony, which is important as you may remember that according to Blackstone, there were two other ways that lands could be colonised, through conquest and through cession, which is essentially a treaty. The difference between settled lands and those that are conquered or ceded is that in the latter cases, something known as the continuity principle applies. This doctrine essentially dictates that in ceded or conquered territories, the local laws of the people there will continue to apply until they are specifically legislated against by the colonising nation. Now, for settled colonies such as Australia, there is much greater difficulty in acknowledging the continued existence of local laws, since supposedly, according to the doctrine of terra nullius, no one was there in the first place. As such, from the point of colonisation up until about the mid-1830s, there was undoubtedly confusion about whether Indigenous customary law continued to apply, particularly for criminal convictions. There was no great concern over trialling Indigenous people for crimes committed against one another, rather only those committed against colonists. The New South Wales Supreme Court even expressed concerns to the Attorney General and the Colonial Office over whether they should be permitted to trial Indigenous people at all, given that Indigenous communities could regulate themselves. The matter was left largely unresolved until 1836, with the key case of R. Murrell. In this case, Jack Congo Murrell was tried for the murder of another Indigenous man. The victim was said to be part of a group that killed Murrell's brother, and as such, it was argued that the murder fell within the native custom of revenge killing. Murrell's lawyer in that case argued that at the time of Australian colonisation, Australia was a country having a population which had manners and customs of their own, and we have come to reside among them. Therefore, in point of strictness and analogy to our law, we are bound to obey their laws, not they to obey ours. There were essentially two challenges being made here. Firstly, to the notion that Australia was indeed terra nullius, and secondly, to the ability of colonial courts to trial Indigenous people. The Supreme Court did not respond positively to these comments, and it highlighted that if the offence had been committed on a white, he would be answerable. But the court could see no distinction between that case and where the offence had been committed upon one of his own tribe. Justice Barton stuck strongly to the terra nullius and colonial birthright theory guns, arguing that Australia was taken by occupation, and as such, the Crown was able to take possession of the whole of Australia and have its laws apply to all those that lived there. Indigenous crimes would hence not be dealt with via the customary laws and traditions of Indigenous communities. The English criminal law system would simply not permit customary law to coexist with it. Moving on to perhaps the most notable legal matter that has been the subject of loads of change over the last century: Indigenous land rights, or native title. To understand native title a little bit more than simply Indigenous people have rights in the land in some cases, there's a few things we need to understand. The key concept to understand when considering how Indigenous peoples were dispossessed of their lands is the English doctrine of tenure. The doctrine of tenure operates in Australia today and dictates that all land is owned absolutely by the Crown. The High Court confirmed in Attorney General of New South Wales and Brown that the doctrine of tenure was received into Australia upon colonisation, and this makes sense to us, given that the doctrine of tenure as part of the English common law would have been received in accordance with the colonial birthright theory. The attitude towards the nature of the doctrine of tenure was maintained for over 2 centuries, with a quote from Justice Isaacs in Williams and Attorney General providing an excellent summary of the viewpoint. It has always been a fixed principle of English law that the Crown is the proprietor of all land for which no subject can show a title. When colonies were acquired, this feudal principle extended to the lands overseas. And until Mabo No. 2, the universal and beneficial ownership of the land by the Crown was believed, and this prevented the existence of native title. There was an attempt by Justice Blackburn in the case of Mirpin and Nabalco to recognise the pre-existing system of laws of Indigenous peoples, though he ended up simply following precedent and merely categorised the Indigenous relationship with the land as spiritual. So now we come to the Mabo decision itself and need to consider how this changed the interaction between English law and the Indigenous land rights. The case itself concerned a declaration that was sought to classify the Meriam people's customs and laws as legal rights of ownership over the Murray Islands, as well as the surrounding seas, seabed and reefs. The Queensland government had attempted to eliminate any native title that may exist by enacting the Queensland Coast Islands Declaratory Act of 1985, but this was found by the High Court to be invalid due to being inconsistent with the Racial Discrimination Act of 1975. The main issue in Mabo, therefore, was whether the Crown had gained absolute beneficial ownership over the Murray Islands upon gaining sovereignty in 1879. In the event that this was not the case, it may have been possible for native title to remain intact, since no acts since 1879 had extinguished native title in the Murray Islands. In the decision, the importance of acknowledging the previous ownership of Indigenous Australians was recognised. However, it was also agreed that Australia was still to be regarded as a settled colony. Rather than completely reversing the effects of the Terra Nullius Declaration, the court went about changing the understanding of the doctrine of tenure. Upon settlement of Australia, the English were entitled to claim governmental authority over the land, but they did not in fact acquire an absolute or beneficial ownership due to the presence of Indigenous Australians. They instead acquired a kind of radical title, one which would permit the granting of land under the doctrine of tenure. The judgment of Chief Justice Mason and Justice McHugh described the situation as follows. What the Crown acquired was a radical title to land and a sovereign political power over land, the sum of which is not tantamount to absolute ownership of land. As such, grants of land made under the doctrine of tenure would only extinguish native title rights if they were wholly inconsistent with one another. If this was not the case, then it is possible that native title rights and the doctrine of tenure could coexist. So the tenurial system in Australia can best be viewed as follows. Land ownership can be derived either from the doctrine of tenure or from the autonomous system of native title rights. The relationship between the two can best be described as this. The native title rights are like an encumbrance on the radical title of the Crown. So, what is the final picture we can see of Australian colonisation, the inheritance of English law, and its interaction with and effect on the Indigenous customs, laws, and native title? Well, it isn't a pretty one. Australia was incorrectly categorised as terra nullius due to the narrow-minded interpretation of Indigenous societies by the British. As a result, all English common law was received into Australia in accordance with the colonial birthright theory, with equity and statute law not being officially received until the enactment of the New South Wales Act and the Australian Courts Act. As a consequence of this, Indigenous customary law was almost completely disregarded, and native title rights took over 2 centuries to even be recognised. So that's it. Thanks so much for watching the video, and I hope you enjoyed History in a Nutshell.